Let's jump right into this story. Okay, so this is a story of Jeff Younger and James Younger. Jeff Younger is the dad. James Younger is the son. Contrarian, I've got your AI generated story. We'll do that in a little bit. Jeff Younger is the dad. James Younger is a son who allegedly wants to become a daughter. Jeff and his wife divorced. The wife is a medical doctor who has decided that her son needs to be a little girl. Why? Oh, I don't know. Probably because it's popular fucking book club. You will not ever catch me agreeing with the idea that children, especially as young as James, make decisions about their gender identity in this way. I think fully that we have fucking manipulation from an evil, self-interested parasite in Jeff's ex-wife to convert this child to the fucking teachings of transgenderism, to sacrifice little James on the altar of her social credit score. And you cannot fucking convince me otherwise. And we'll talk about some evidence of that in this very story. So here we go. This is from the Post Millennial. This is what happened on December 31st, or well, this is the reporting from December 31st. This all just happened in the past couple days. Breaking: Texas Supreme Court rules against father seeking to prevent chemical castration of his son. Remember, the Texas Supreme Court, they're Republican. They're based in red pill. Do not put your faith in judges. And specifically, look, the family court system, people make some mistakes about me. They say Nick defends the family court system or whatever. No, the family court system is better and getting better in regards to men and women divorcing. Stop. Stop, 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 stop. It also depends on the state, but just in general, it's getting better in many, many states, including Minnesota. It's not good. It's not great. It's not perfect, but it's getting better. I think that trend is good. On this fucking shit, it's not getting better. It's not getting better. Okay? I'm not here to defend a fucking family court. And I'm not here to defend an appellate court. And I'm not here to defend the Texas fucking Supreme Court. Family court in Texas is one of the most disgusting, toxic things. And everyone ignores it because, well, it's Texas. It's probably okay. No, it is not. No, it is not. And the other thing that you need to know, for me, and I think Drex and I have agreed on this a couple times, despite our general disagreements on the family court, some of the biggest problems in family court issues involve male older judges specifically. You're not getting a fair shake as a man with a male older judge in family court. Why? Because they have different notions about the suffering of men. They have different notions about what men go through these days. They kind of unplug from society. They don't see what's happening to men out there. I would much rather have a female family court judge than a older male family court judge. Maybe a young man family court judge. Maybe. I don't want to be in family court ever, for the fucking record. But if I had to pick, old man family court judge is about as far fucking down the list as I can imagine. Because they'll tell, oh, well, you just have these, they have these older ideas about stuff. And I think that's kind of validated when we see some Supreme Court shit related to it. These are the oldest of the old judges. Supreme Court of Texas denied my mandamus, effectively terminating my parental rights. My children are now subject to being chemically castrated in California. Texas is an empire of child abuse led by Texas judges, he said. And he's 100% right on this. We saw it with the Michael Long case. We saw what Texas does to fathers specifically. I've talked about the corruption in the Texas family court system very, very specifically. And I don't know how else to talk about it. But if you're a dad in Texas, be very, very cautious. I'd be very scared to leave my rights in the hands of a judge. Very, very scared of it. Now, does this mean all dads are fine and all moms are bad? No, of course not. Family law is really fucking complicated. But there's some very clear abuse. There's some very clear manipulation going on in the Texas family court system specifically. It's terrifying. The best bet is to be good husbands, shore up your marriage, and marry good women. Jeff says don't get married and don't have kids under these laws. That's where his experience has taken him, by the way. All right, here we go. Jeffrey Younger has lost his court case to prevent his ex-wife from taking their son to California, where he could be medically transitioned. Younger has been trying to stop this from happening for years and said that he has now reached the end of the line. He wanted the courts to stop his ex-wife from taking the children to California and to protect his boys from medical mutilation at the hands of their mother, who's a pediatrician. The courts prevented him from forcing the mother to bring the boys back from California. Younger has accused her of using the children to help advertise her inclusive, gender-affirming practice. We've got, by the way, we've got the ruling from the Texas court. I'll show you, but let's read the article first. Let's read the article first. The Supreme Court of Texas denied my mandamus, effectively terminating my parental rights. My children are now subject to being chemically castrated in California. Texas is an empire of child abuse led by Texas judges. This after Judge Kim Cooks on October 24th said that both parents should have a joint managing conservatorship, with each able to have a say in his medical treatment, the Texan reported. Yes, Judge Kim Cooks did this. She actually was the one who said they should have equal say. That got overturned. The custody case was before the Supreme Court of Texas, which ruled against Younger. Younger had issued a petition on December 16th to try to retain his parental rights after his ex-wife, Dr. Ann Georgalis, took the boy, Georgalis, I don't know, Gorgalis, took the boys to California. California has a law in place starting on Sunday that children in the state will not be returned to their home state in the event that the home state would prevent the children from being medically transitioned to present as the opposite sex. Younger wanted the boys brought home. California Senate Bill 107. So here you go. This is California's sanctuary tranny bill, where you can take a child to California to get transitioned. And if it would have been illegal in the other state, too fucking bad. Even if there's an active custody order. Because it's a sanctuary state, you know. Let's see. California Senate Bill 107, proposed by the state senator Scott Wiener and signed into law by Governor Gavin Newsom, will prohibit the enforcement of an order based on another state's law authorizing a child to be removed from their parent or guardian based on that parent or guardian allowing their child to receive gender-affirming health care or gender-affirming mental health care. So there you go. This is a huge, I can't explain enough other states are effectively required to respect the ruling of the custodial state. Texas is a custody state here. Texas has the custody order. Parents were in Texas when the order was signed. Parents were in Texas under the effect of the order. Mom flees Texas with kids. Dad tries to stop them. Texas won't step in, but the order's still in Texas. They go to California. Texas should be ruling on this. That's how it should go. That's how it would have gone in any other issue. California creates a law that says, nope, we won't cooperate in this. We will not do what we would do in every other family law case just for mutilating a child. If this doesn't boil your blood, I don't know what will. Run like the Winded says SCOTUS. They don't get involved in family law stuff almost ever. Almost ever. Plus, by the time he's done it, his kid's going to be a chick, probably in a fucking sorority at that point. Younger's concern per his petition is that in California, his son would be subjected to transgender procedures deemed to be child abuse by the official opinion of the Texas Attorney General. Texas has laws against the medical gender transition of children and teens. That it does, but they won't protect your kids. They won't do it. The children would lose the protections of injunctions on the mother that prevent her from chemically castrating the children or sexually mutilating them in transgender surgeries, Younger said in his petition, according to the Texan. Younger was married to pediatrician Georgelis. She and Younger ended up in court fighting over the children when she believed that James Younger's 7-year-old wanted to live as a girl called Luna. She petitioned the court to prevent Younger from, quote, signing Luna up as James for any activities or taking her as James or calling her James or using male pronouns related to Luna at any activities outside the home. Last time I met someone named Luna, they were a stripper. I just want to point that out. Gorgelis began to believe James was a girl when he asked for a girl's toy from McDonald's and wanted to wear dresses, as well as began to emulate the female lead characters in Disney's Frozen. He was a counselor at the Genesis Clinic at the Children's Hospital Center who advised Gorgelis to socially transition James, according to court documents. Gorgelis was affiliated with that hospital. Well, he liked a girl's toy. There you go. Make him a girl. From McDonald's. What was it? Was it Frozen or some other thing? Like, because that's what they do, right? Like there's a girl's toy and it's for some popular thing that a bunch of kids watch. Younger, who had joint custody in 2019, was and remains entirely against the course of action. When James is with Younger, he does not ask to be called Luna, does not seek out girls' clothes, yet a court determined that Younger must use the pronouns and names the ex-wife demanded. In a video posted to the dad's website, James is asked, "You're a boy, right?" Heavy reported, "No, I'm a girl." "Who told you you're a girl?" "Mommy." The child said Anne also put James in dresses. "She buys me headbands. She gets me hair clips. She paints my nails." "Do you think you're a girl?" The child answered in the affirmative. Gorgelis was awarded custody by the Texas courts in 2021. Dallas County District Court Judge Mary Brown awarded Gorgelis full custody of James. Brown also eliminated the requirement that Jeff Younger be notified about James's medical procedures, except for instances of hormone suppression therapy, puberty blocking drugs, and gender reassignment surgery. Under that order, Younger must consent to any decisions made under those categories of the procedure, the Texan reported. Witnesses who knew the boys and could attest that James did not identify as a girl when left to his own devices were prevented from testifying in the case. One mother of the boy's friend said in testimony she wasn't allowed to give in 2019 that, quote, so she wasn't allowed to say this in 2019 in court. Quote, "Over the past year, I've observed that James is blissfully happy as a boy. He loves to march around outside and yell, 'We are the only Boy Scout troop,' or 'I'm the leader of the wolf pack.' He is always the ringleader, even though he isn't the oldest of the group. He loves dressing as a superhero and sword fighting. One day we all walked to a playground near my house, and on the way home, James slipped in some mud and got his clothes dirty. He asked if he could borrow some of my kids' clothes and I could wash his. Of course, I said, no problem, and grabbed him a pair of shorts from the chest of drawers and tossed them to him. I said, hang on while I grab his shirt from the closet. He immediately said, Miss Sarah, I don't need a shirt. It's hot, and boys don't have to wear shirts if they don't want to. Isn't that awesome? He was so cute. I said, yes, that is awesome, as he ran off to play. I did eventually get him to put on a shirt. It was gray with lizards on it, and he loved it. He also likes having his hair cut a certain way, but told my son Grayson that his mom wouldn't let him get it cut too short, even though he wanted it to be spiky. The Office of the Attorney General of Texas filed an amicus letter with the courts on December 22nd, stating a trial court has allowed Relator's former partner to move to California with their children over Relator's objection. There, she intends to provide the child with potentially irreversible medical interventions that may constitute child abuse under Texas law. particularly given that a court has previously found that mom may have overcorrected for any symptoms of gender confusion exhibited by their child. The trial court clearly abused its discretion in permitting relatives' former partner to remove the children from the state, given the ongoing litigation regarding their well-being. And that error may be irremediable on appeal because California has enacted a law makes it difficult, if not impossible, for relative to regain custody of his vulnerable child. When Younger attempted to speak out about gender transition at the University of North Texas, he was prevented from doing so by far-left activists who shut the speaking engagement down. So there we go. That's the story of what's going on with Jeff and James Younger. Now, should we get into the legal element? Should we get into the document itself? This is from the Supreme Court of Texas. It's 8 pages. This is a response to his petition for writ of mandamus. Okay. Justice Blacklock, joined by Justice Young, concurring in the denial of the petition for writ of mandamus. Real quick, a writ of mandamus is a request to a higher court to correct a lower court for something that cannot be resolved by an appeal. Because maybe if they don't do it right away, it will cause irreparable harm. Maybe it's outside of the appellate issue in general, but the lower court has made an error. You ask the higher court to come in and say, nope, we don't want you to do that. If you do that, it'll cause permanent harm that can't be undone. This pro se mandamus petition arises from a child custody dispute involving twin boys, one of whom has exhibited confusion about his gender. Mother, who has custody of the boys, recently moved to California after a Dallas County District Court in September authorized mother to reside with the children anywhere in the continental United States. Father, the relator in this court, is concerned that the mother's move to California will bring about the medical transitioning of his son. 3 months after the district court authorized the move to California, father belatedly seeks an emergency order from this court requiring their return. Oh, yeah, it's belated. Well, it's literally the last option he had, but now it's belated. It's like latches, right? I concur in the court's denial of the petition because father is already in possession of a court order prohibiting mother from doing precisely what he fears she will do with his son. Oh, yeah. No, it's fine. There's a piece of paper that's going to stop her from doing the thing that California will specifically fucking allow you to do. California is going to allow the mother to do this, but he's got a piece of paper in Texas, unenforceable in California, that says she can't. It's nice security, right? Warm yourself with that judgment paper. In October 2021, the district court, with the mother's full agreement and indeed at her request, ordered that neither parent may treat a child with hormonal suppression therapy, puberty blockers, and or transgender reassignment surgery, if any, without the consent of the parents or court order. This agreed order is binding on both parents and enforceable by contempt, no matter where they reside. Oh, contempt? That's nice, right? She can get a contempt fine while his son becomes a daughter. It's okay. It's fine. She'll pay like $2,000 for contempt charge. Should get a stayed contempt confinement sentence. If you fuck up again, we'll put you in jail for 30 days. Your kid's now the opposite gender, has been medically castrated. The effect of the order is that neither parent has the legal authority to consent unilaterally to gender transition therapy for their son, whether that therapy takes place in California, Texas, or elsewhere. Except in California, they literally will. That's the thing. In California, she will have that ability. How's he going to stop her? As long as this order is in effect, mother's parental rights do not include the right to obtain gender transition therapy for her son. This is just as much the case in California as it is in Texas. This isn't true, by the way. And if you've ever tried to enforce an in-state order out of state, you know that it's not this fucking simple. It is not this fucking simple. Here's the scenario. Here's how this works. Mom goes into clinic. She's required to tell Jeff, by the way. She's required to tell Jeff, by the way. So mom goes into clinic. My son identifies as a girl. We would like to start hormone therapy, puberty blockers first, and then hormone therapy to move to an ultimate full transition. What authority do you have? I'm his mother. Birth certificate. I'm a mother. Okay. What you think they're going to ask? So Jeff calls up, hey, you can't do that. Why not? Texas said so. So we're a sanctuary state. Fuck off. Texas order isn't valid here. But you can't. Watch us. Watch us do it. Mother freely acknowledges that she is bound by this order in both Texas and California. What is more, Mother has flatly denied to this court that she will seek to evade the district court's order while she is in California. Oh, I'm totally not going to do it. Really? Really? What is more, yeah. As a result, should she fail to honor her promise as father fears, contempt of the district court's order would not be her only concern. What would be her other concern? What, you're going to get California? Here's the crazy thing. Look at what Texas is doing. Look what the Supreme Court is doing. They're saying effectively that she would be subject to have the child removed, to transfer the custody rights to the dad. But California won't do it. Their law specifically says they won't do it. Texas Supreme Court here is pretending that California is not going to honor its own law specifically against what they're saying will happen. Father believes that California's enactment of Senate Bill 107, which goes into effect on January 1st, will enable mother to evade the Texas court order prohibiting her from unilaterally consenting to gender transition therapy. Father misreads California's new law. By my reading of SB 107, the Texas judge is reading. That's perfect. By my reading of SB 107, father's fears are no more likely to be realized in California under SB 107 than they would be before the bill's enactment. That doesn't make me feel better, you cuck. What the fuck is this? Described by its lead author as a trans refuge bill designed in part to respond to executive and legislative action in Texas, specifically in Texas. It's specific to Texas that they're responding to. And the Texas is like, no, it's not going to happen. The bill certainly casts a wide net in pursuit of its objectives. The bill contains several provisions barring enforcement in California of, quote, a law of another state or another state's law that prohibits gender-affirming health care. Thus, SB 107, both as advertised and as written, is California's response to other states' legislative enactments or administrative rules outlawing gender transition therapy. While SB 107's position on other state laws is clear, I see no provision in the bill that would alter the enforceability in California of a Texas court order requiring divorced parents to agree before subjecting their child to gender transition therapy. Wait, why not? The law of another state or another state's law is literally the enforcement of fucking court orders, judge. Are we going to pretend that the contempt order that you're demanding is not a Texas contempt order based on a Texas order? They're just going to sit here and pretend that none of this will happen. Like, oh no, well, can't happen. Father reads SB 107's prohibition on the enforcement of another state's law against gender transition therapy as a prohibition on enforcement in California of court orders limiting access to such therapy. It is not. No citation, by the way. A court order allocating the parental rights of divorced parents based on case-specific judicial findings about the best interests of their children is in no way a law of another state. No, it actually is. It is because it's only enforceable by the laws of the other state. This is crazy. And in the very unlikely event, California's courts, it won't get to it. Like, California courts won't get to this. Interpreted their statute in such an odd way, they would, of course, run headlong into the full faith and credit clause, U.S. Constitutional Article 4, Section 1. Oh, yeah. Well, that'd be great. 5 years from now, when this might hit the Supreme Court, he can find solace that his now daughter should not have been. Insanity. It's fucking insanity. The bill's authors were likely aware of the prevailing... Likely! They have nothing. There's no citation to anything in this. The only citation is the press release of Scott Wiener. They were likely aware of the prevailing interpretation of the full faith and credit clause, under which states have some leeway to deny enforcement of other states' laws on policy grounds, but little or no leeway to deny enforcement of other states' court judgments. The U.S. Supreme Court's decision, quote, decisions support no roving public policy exception to the full faith and credit due judgments. That's Baker versus General Motors Corp., which, by the way, is not a family court. And I want to point this out. Because this is a critically important distinction. Family courts operate different than damn near every other court. Other courts operate on law. Family courts operate on feelings. There are some laws to restrain those feelings and constrain those feelings. But the ultimate standard is called the best interest of the child. And that tends to be in what a district court judge, where there is jurisdiction, has the idea. The longer that little James is in California, the more likely it is that California will have jurisdiction over little James and their custody agreement. And sure, they can consider the custody agreement of Jeff and Anne. What they can also do is decide that Anne has full medical custody because she is the custodial mother. She is the one making medical decisions. She is the one with most interaction towards James. She is the one who is overseeing his therapy. She is the one who is witnessing his personal transitions. Jeff has become a public figure against transgenderism. He's biased, blah, blah, blah. Anne is just harmlessly trying to help her child. She can challenge the order. She can move for a modification of the order. She can do all sorts of shit that this judge is just fucking ignoring. And Texas won't have jurisdiction, and the Texas order will not stand. A modification of the order in California will modify the Texas order straight out. There will be no reprieve from it. Jeff won't be fighting this in Texas, by the way. That's the crazy thing. Jeff won't be able to haul Ann and James back to Texas to fight this. This is why it's the end. He'll have to fight any future battles on this in California with all that entails. Oh, they have to honor the Texas order. No, they don't. They can modify it. Best interest of the child. All right. Understanding this important distinction, evident throughout the text of SB 107 between another state's law and the actions of another state's courts. Notice this isn't quoted. How is the distinction evident? It's not actually there. That's a fiction. Is essential to correctly understand the very limited extent to which California could refuse recognition of the Dallas County District Court's child custody determinations, even if it wanted to do so. What are you going to do? Take it to the California Appeals Court and the California Supreme Court? U.S. Supreme Court? Well, SB 107 treads close to territory prohibited by the full faith and credit clause. and ultimately may be found to transgress it in various ways. Nowhere does the bill purport to prevent enforcement in California of out-of-state child custody orders, establishing which parents may consent to gender transition therapy, except they can take on the order and modify it if she just waits long enough. 6 months, by the way. She's already been there for 3. To summarize, under an existing Texas court order that mother agreed to and that mother acknowledges is binding on her, mother lacks the legal right to consent to gender transition therapy for her son. And of course, after just a little bit of therapy and advice from a gender affirming counselor, the mother can say there has been a new development, new change. New evidence. We need to reconsider. We need to modify. This legal disability is just as real in California as it is in Texas, and mother readily acknowledges this as well. When a custody order specifies that joint parental consent is required, then a California doctor, just like a Texas doctor, must ensure that the appropriate parents have consented to treatment administered to their children. Citing People versus Superior Court, California 2008. Under Family Code Section 3083, a court entering a joint custody order must specify the circumstances in which joint parental consent is required. In all other circumstances, the consent of one parent is sufficient. That doesn't say what they wanted it to say, so that's nice. Under the district court's order, any doctor in the state giving gender transition therapy to father's son without father's permission would do so without the lawfully required parental consent. Nothing in SB 107 changes any of this. Okay, so again, see American Academy of Pediatrics versus Lundgren. The requirement that medical care be provided to a minor only with the consent of the minor's parent or guardian remains a general rule both in California and throughout the United States. But again, they'd have to rely on enforcing a Texas law and a Texas order. Nothing in SB 107 changes any of this. It's not true. Father's further concern. And here's why I'm saying it's not true, guys. If I were this woman's lawyer, I'm making all these arguments as to why she is correct. And if retarded me is doing it, a much better lawyer, a much better family lawyer, hired by a pediatrician, presumably with significant resources, is making much better arguments, is making much more significant and well-researched arguments about how that Texas order falls afoul of SB 107 and the Texas cannot enforce this consent order, which is wrong, or how they can modify it. Like, if I'm here opposed to this, able to make very simple arguments as to why this is wrong, a very good lawyer in California will shred this Texas. This is a denial of mandamus, by the way. This ruling is just them denying his petition for mandamus, which means that this ruling isn't actually binding on a California court. This order does not say that a California court or a California clinic or a California doctor or a California lawyer can't do what she wants them to do. This just says, we won't help you, Jeff, fuck you. That's what this says. That's all this order does. The previous order is the operative parental consent order. It can be demolished by a court. It can be modified by a court. Could be honored by a court. But what if it isn't? But what if it isn't? And his only recompense in this is that his son will already be permanently damaged. Father's further concern is that a California court could undermine the Texas order at mother's request. Gee, why would he be concerned about that? I don't know. I would. He points to the following provision of California law amended by SB 107 is shown in bold. A court of this state has temporary emergency jurisdiction if the child is present in the state and the child has been abandoned, or it is necessary in an emergency to protect the child because the child or sibling or parent of the child is subjected to or threatened with mistreatment or abuse, or because the child has been unable to obtain gender affirming healthcare or gender affirming mental health care as defined by section 16010.2 of the Welfare and Institutions Code. Gee, why would he be suspicious of this? Why would he be fucking suspicious of this? Oh, I don't know, because it's in the goddamn law. Specifically. California Senate Bill 107, Section 5, a version of which is the law in both California and Texas. Oh, wait. Under the Uniform Child Custody Jurisdiction Enforcement Act, a version of which is the law in both California and Texas. A California court is obligated to respect the Texas court's custody orders and cannot modify the Texas court's orders unless the Texas court relinquishes jurisdiction, an action reviewable by mandamus. Oh, that's nice. Yeah, he can get mandamus requests for them to not relinquish jurisdiction. So the Supreme Court's they're gonna hold on to that one for him. Father is nevertheless concerned the above quoted provision could be used to temporarily authorize gender transition therapy in direct contravention of the Texas order. Quote, even before SB 107, a California court that considered lack of gender transition therapy to be an emergency case of mistreatment of a child could have invoked temporary jurisdiction under section 3424A. SB 107 makes lack of gender transition therapy an explicit ground for finding an emergency. So even before it was there, it was allowed. That qualifies for temporary emergency jurisdiction. But a judge inclined to view such a situation as an emergency threat to a child was already empowered to invoke temporary emergency jurisdiction. SB 107 does not mandate that courts find that the lack of such therapy constitutes an emergency justifying temporary jurisdiction. It leaves that question entirely up to the courts, as it was before SB 107. The fucking justification is that it was already that way. That is... Do we see how fucking insane this is? Well, it's already that way, so who cares? This law just moved from ambiguity to certainty. That's what it did. But we're supposed to pretend that that doesn't mean that that matters. Like, well, they could already do it, but I didn't want them to do it before. Yet to obtain such an emergency order from a California court, mother would have to take the position that existing court order she agreed to now poses an emergency threat to her child. That's not hard for gender transition. Mother has repeatedly asserted in court that the Texas order is desirable and in the child's best interest, which would make it quite difficult for mother to argue the contrary position to a California court, even if that were her intention. No, it would not. It would not make it hard at all. The father has become belligerent. The father has gone to the media. The father is trying to exercise control beyond his thing. The father is not present for therapy. The son, the son who wants to be a daughter is presenting symptoms that transition needs to happen now. Puberty is approaching. I think the kid's 12 or 13 now. 9 in 2019, I think I saw, which makes 12 to 13 years old now. Hormone blockers are essential to prevent puberty and prevent permanent changes to the child, blah, 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 blah. All of this fucking shit is imminent. It's ripe right now. For easy arguments. I don't even study this, and I can make basic arguments as to why it's an emergency order. Just knowing the cultural zeitgeist around this shit. Mother would also have to claim that the emergency is so dire that there's no time to ask the Texas court to amend its order. A highly doubtful proposition in the age of video hearings. Why? Why? Why not just take it to the California court? Ask the Texas court, have them take jurisdiction over it. Kid's been here for 6 months. We're under California law. It's crazy. California court would have to consult with the Texas court. Okay. And the California court would have to decide to take the extraordinarily unusual step of issuing an emergency order directly undermining another state's court order, even though the other state's court was readily available to hear a request to modify the order. Yeah. Again, I don't buy it. They have a new bill, a new law that says that they can. Concern that any of this will happen would be entirely speculative in any case. In this case, given that mother has now represented to both this court and the district court that she has no intention of trying to make it happen, it is not merely speculative, but potentially prohibited by principles of estoppel. Nope, not a chance. See, here's the thing with family law. Principles of estoppel stop things like contracts. They stop property transactions. They stop stuff that makes sense. They stop stuff with inanimate objects that have values attached to them. Children are not inanimate objects. That's what makes family law unique to everything else. Children, husbands, wives, ex-husbands, ex-wives, they're not these constant things that exist with values attached to them. Their values change over time. Their emotional status changes over time. What's good for them, what's healthy for them changes over time. All of this shit changes always. Principles of estoppel don't work with people. They work with things. This isn't about things, this is about people. This court cannot intervene based on tenuous speculation about what other courts might do in the future at the request of a party who may never ask. The only court to have acted so far has preserved father's right to withhold consent to gender transition therapy for his son. That right is enforceable in California, where mother lacks the legal authority to consent to such therapy for the child, both before and after SB 107. If the district court modifies the October 2021 order regarding medical care or attempts to acquiesce in a California court's desire to do so, father could seek immediate appellate relief. He could. This court makes every effort to consider pro se filings with rigor and with leniency. Apart from its misunderstanding of the law, father's petition suffers from other procedural and substantive defects that would make granting it problematic. Given the complexity of this case's history and the sensitivity and novelty of many of the legal arguments involved, father would be well advised to seek competent counsel if he again pursues relief in this court. Dude, you broke him already. He's fucking broke. That case might raise important questions about whether medically or surgically transitioning a child against the wishes of a fit parent can ever be in the child's best interests. With regard to these children's best interests, I find it troubling that father has refused to see either of his children in over a year despite abundant opportunities to do so. Oh, here we go. Here we go. They're telling you exactly how they're going to rule. Even if it comes up in Texas, they're going to rule against him. It's right fucking there. I find it troubling. You need no other language than that. The Supreme Court of Texas has already said. It's kind of troubling. Probably go with the mother's perspective. Here we go. This is not that case. I respectfully concur in the denial of the petition for writ of mandamus. That's from James Blacklock. Justice. So he claims. Why hasn't he seen the children? I don't know. I have no idea. I don't remember the let's see. I don't remember why he hasn't seen the kids. For one, they're in California now. I'm trying to remember. I think there's like some requirement that he needs to do, if I remember right. It might be in the interview I did with him. I don't remember. Let's see. Let's see if I can find it real quick. I think he might have talked about it. I think he talked about it in my interview with him. Duck Dangerously, it says, I think he said that all visits were monitored and that he had to address James by his girl name. Something like that. Yeah, I don't remember the specific reason why he hasn't seen him, but look, again, as someone who has done family law, as someone who has been a foster parent specifically, um, supervised visits are something. There's something really, really interesting. And I don't know the specific instances here. Oh, here we go. Jazak says he hasn't seen the boys because it would cost him $600 for 2 hours. They're going to make him call his son Luna, and the boy had to appear as a girl. He said they had no right to compel him. So there you go. There's the answer for you from Jazak. Thank you. So he has to pay. He has to pay to force himself to participate in a fiction. And it would be supervised at a facility. So it's not like he gets to bring them home to his house. He has to go to a place, 2 hours, $600, and he has to refer to his child as Luna. He has to affirm their gender. So there you go. There's your answer. I find it concerning that he hasn't seen his kid. And that was while he was in Texas, if I remember right. That was while the kid was in Texas. That's before. Now, if he wants to see the kids, he has to go to California to do that. So he also has to buy a plane ticket. So it's a nasty fucking case.